If you are a property manager or a landlord, you really need to understand and master a set of rules we call the 45-day letter rules. There is a statute in Indiana that governs the manner in which a property manager or landlord takes care of the security deposit that is given to the landlord from the tenant. This only applies to residential lease agreements, so it wouldn't apply to a commercial lease. But the essence of the 45-day rule is important, and it is the following. Within 45 days after the landlord gets possession of the property back from the tenant, the landlord has to send an itemized list of damages and the balance, if any, of the security deposit back to the tenant. This has to be in writing, has to be mailed to the tenant at the tenant's forwarding address if the landlord has the forwarding address. There's a set of guidelines, if you will, that we prescribe in the event that the landlord does not know where the tenant has moved. And you can read those guidelines on our website. Just go to the search bar and search 45-day letter rule, and you'll be able to pick those up. Now, the consequences of violating the 45-day letter rule are significant. Generally speaking, with one major exception, if the landlord doesn't satisfy the 45-day letter rules, the landlord has to give back the full security deposit and cannot sue the tenant for any damages. That one exception, which is an important one, is if the unpaid rent from the tenant to the landlord equals or exceeds the amount of the security deposit, then the landlord's going to win that case. That was decided in an Indiana Court of Appeals decision a few years ago, and it's a significant departure from how the security deposits and the 45-day letter rules were treated previously prior to that appellate court decision. This is really important, though, because as I said, the tenant can do significant damage to a property, and if the landlord fails to satisfy the 45-day letter rules, tenant wins, landlord loses, and that could be very costly to the landlord. So we recommend that you use a 45-day letter rule that matches the form and substance that the Indiana Court of Appeals has prescribed. And if you don't know what that looks like, then you really need to talk to a real estate business attorney who understands property management and landlording, and get a good form that you can use on a consistent basis. You got to understand these rules. There are more complexities to this rule, and again, you can learn more about the 45-day letter rule from articles and blogs on our website. Thank you.